Hello, Chris McCardle is my name. It's my pleasure to talk about fidelity and good faith. There's a case of Barker versus the Commonwealth Bank in late 2014, which found that there was an implied duty of trust and confidence that it was not to be found in employment contracts. I personally was not aware of why we would be having that debate in any case, because most of the authorities found that an implied duty of trust and confidence did not apply on point of dismissal. So therefore there was no jump available from the implied duty of trust and confidence into a person not having to, not expecting to be terminated other than procedurally, fairly or reasonably or anything like that. So the implied duty of trust and confidence was only within the contract. It was the cases that had led to it had not provided for any pecuniary benefit to employees. It was all rather academic. The case of Barker versus the Commonwealth Bank, however, had an implication whereby Barker would have received an award of money as a result of the upholding of the implied term of trust and confidence. Well, the High Court found that there is no such thing in an employment contract in Australia. What they purposely held open was that there is an implied term that still exists. The question that was left open, and therefore it still remains as law, subject to some future challenge, is whether or not there is an implied term of fidelity and good faith. Although it must be said that there's no implied obligation to act in good faith in contracts of employment in Australia, it's clear that an obligation can be imported into a contract by express or implied provisions. And French, CJ, Bell and Keenan at paragraph 42 of Barker, if you want to look it up, said expressly left open the question of whether there is a general obligation to act in good faith in the performance of contracts, and whether contractual powers and discretions may be limited by good faith and rationality requirements. And Justice Kiefel, in the same way, had an open mind on the matter. So whether or not the facts of the employment contract mean that both sides should act with fidelity and good faith really depends on the construction of the contract. It's not a blanket statutory obligation, nor is it universally applied. And I think the courts are willing at this stage only to keep an open mind on it, so that they can look at the facts of each matter as it arises, rather than a general principle in every contract. So if it's implied by fact. Now, what would the facts be? Say there's an implied duty that an employer not require an employee to act illegally. Obviously, that's an implied duty that's implied by law, but if we step back from law and talk about implied by fact, what would be an associated concept of implied by law in that? That would be an implied duty that a person not be obliged by the employer to act in, say, sharp practices. You sell cars that cost too much when it's well known that the retail price of the car is not what it's been represented to, and so on. Or present an investment vehicle and exaggerate the safety of the investment vehicle to a bunch of old pensioners who are anticipating getting more than they're going to get in interest repayments if they invest with you, that sort of thing. Or that you can't have, or you think there's a significant doubt, and you don't tell them there's a significant doubt. You misrepresent the value or the attractiveness of something. And is there an implied term that the employer can't require you to act in that particular way? And that would be acting towards you with good faith, not putting you in a position where you're going to damage yourself, not legally damage yourself, but damage yourself in terms of your reputation within the community. And with that is the obligation of fidelity, which I'll come back to in more detail. So there must be some sort of obligation that people will treat each other with respect. That's the statutory concept of bullying laws. You cannot act in a way that undermines the health or safety of people. That's a statutory obligation, section 789 FF of the Fair Work Act. You cannot unreasonably behave towards a person so as to cause them damage. You cannot unreasonably act towards a person so in a way that is not reasonable and not in their best interest. You are not therefore by implication acting in your own legitimate best interests. So there's an implied term that a person in working for you is not going to compromise themselves. Also, there's an implied term, it's duty of care, the naked PowerPoints, not placing person in a place of danger, duty to provide work to certain categories of employees and in certain circumstances, and so on. So there is an implied duty of fidelity and good faith, but it's a mutual thing. Now, in other jurisdictions, and there's one from Singapore which is very useful. In this one, in Smile Inc., a person was a dentist, and that dentist set up work as a dentist down the street, and started to take customers away from people. Now, this is not segueing into a discussion on restraint of trade, because there was no restraint of trade. Probably an oversight on their part, this person was able to set up shop down the street and did so, but he was sued on the basis of he had breached his obligation of fidelity. So he started his own business. Now they said, used their time, their resources, and while he was supposed to be working for them, he had set up his own business whilst in their premises and in their employ, therefore acting against the implied term of fidelity and good faith. So they said that he had an obligation of fidelity not to have set up his own business while he was working for them, but he had breached both the express and restrictive covenants and his fiduciary duties. Now, there was a distinction drawn, and it's drawn in all the authorities, between good faith and fiduciary duties. The both duties of good faith and fiduciary duties may arise, but the case they referred to as Man Financial, it's a Singaporean case, 20081 Singapore Law Reports 663, and that in that case it was held that it is trite law that there is an implied term in the employer's favour that the employee will serve the employer with good faith and fidelity, and that he or she, the employee, will also use reasonable care and skill in the performance of his or her duties pursuant to the employment contract. It is thus eminently clear from the case that the duties of good faith and fidelity will exist in every employer-employee relationship. You have to act faithfully towards your employer, not take secret commissions, and there's a lot of that in the common law, not act in a way that damages them, just as they're not going to act in a way that damages you. And that's where I think the implied term of fidelity and good faith is probably mutual, and probably be in due course found to be mutual. Now, if we continue to look at the case of Smile Inc., the court made reference to something that's probably the bleeding obvious, and that is when it comes to the duties of an employee, those duties increase and become more substantial the more senior the employee becomes. The duty of fidelity and good faith of, say, a labourer on a building site B, other than to show up, do your work you're paid for and be gone. That person could, if they like, conduct any business they like in their own interest, so long as it doesn't interfere with their work. But they really have no access to secrets, no confidence, no reporting line to senior managers or anything like that. They do have a duty to loyal, faithfully, diligently and efficiently and not illegally perform their duties, but that's probably it. Whereas up the line, when a person gets to know what the vulnerabilities of the architectural designs are, or what the markups of the building products are and so on, that person, when they get the secrets of the employer, probably have a duty of acting with faithfulness towards the employer while they're in employment. There's a distinction, there always is, and it's important not to be meandering into the confidential information covenant that applies to everybody. That, getting back to that builder's labourer, for instance, to the extent that the builder's labourer knew exactly what was going on and would not have known anything like that, wouldn't known anything about the vulnerabilities or aspects of the employer's business, but for working for the employer, then that builder's labourer has an obligation to keep all of that confidential. Just as with the obligation of fidelity and good faith, that obligation evolves with seniority. It's unlikely that there would be any sort of fidelity other than what I've already described for a builder's labourer. Just as unlikely that such a junior person would have any secrets at all that they're obliged to keep to themselves if and when they leave, either during or after the employment. So that there's a lot of what's being said here is about people from middle management up, not junior clerical employees without accountabilities, although there are instances where junior people would have such accountabilities, such as, say, a word processor operator who's typing confidential documents would have an obligation to keep that to themselves both during and after the employment, and to not, in the course of the employment, use that knowledge against the employer, only use that knowledge for the employer. That's fidelity, faith, good faith. The idea of competing against the employer, you can't serve two masters, so you can't be working at one place and actually profiting another place, or working for one person and profiting another person, particularly if that person is you. That's also closely related to such concepts as secret commissions. If it is corrupt and illegal, and it's a statute barred in Australia, where if the supplier of the paint to the building site actually pays the foreman $100 to deliver the paint to the building site, that is a secret commission. Well, at common law, that would also be a breach of fidelity and good faith on the part of the foreman, acting against the interests of the employer. Your reward is your income from your employer. Your reward cannot be procured yourself from what otherwise would be the benefit of the employer's business. Then, so if you did something like, and this is what they talked about, some examples in this smile matter, acquiring the business of the employer's direct competitor and conducting business using the acquired company. If that happened, then you're working for your employer, and you've actually just bought out the business. That's the business of the direct competitor, undertaking highly skilled work for a direct competitor. Now, this is where the idea of moonlighting comes in. Statutory bodies such as the police force have very strict rules about what you can and cannot do other than working as a salaried police officer, for obvious reasons, because of conflict of interest in a legal sense. But there are many examples, and probably no need to set them out. But if you are, and this becomes more relevant the more senior you get, if you're working for somebody and you want to get a supplementary income working for somebody else doing something else, and that something else is going to be result in your employer being worse off, not so by A, being denied your services for the agreed period, or B, you're in the market in competition with the employer, then you're breaching your duty of fidelity. Again, it's probably less obvious, but if the employer is going to act in a particular way whereby you are diminished, like say expose you to some client of ill repute, whereby you will be tarred with that brush, then the employer has a right to faithfully and honestly let you know what's happening and give you the option not to be associated with that client of ill repute. Obviously not true for lawyers. If there were no clients of ill repute, where would we be? Then if you, and this has happened, solicit the employer's customers and the employer's employees to join a company incorporated by the employee to compete with the employer, the obvious remedy, if that was discovered, the obvious remedy would be dismissal, and dismissal for misconduct, because that is conduct at variance with the employment contract. Now, it doesn't say in most employment contracts, I'm sure, that you can't do that, but it would be a very clear implication, but fact and law, that you cannot, whilst employed, act in competition with or in a way that disrupts the employment of the employer, or entering into agreements with actual and potential customers. So I've actually had several cases along those lines. It's good to hear it's also illegal in Singapore. There's so many other things to talk about in terms of what implied terms there are, but the principal ones are obedience and cooperation, and these words are probably interchangeable in a substantial way. Now, fidelity and good faith means that you're going to do what you are reasonably directed to do. You're employed and you are paid and you're given something to do, and you're going to do it, and that's obedience and cooperation. But then cooperation by the employer is you're not going to employ somebody, call them General Manager New South Wales, and then expect them to be nothing but a sales rep selling tractor tyres in Newcastle. That's not going to happen, because that has that breaches the aspect that's taken for granted in every career. That is, every job you've got is going to give you your next job. So if your job, because of the actions of the employer, undermine your career prospects and undermine your capacity to get your next job, then you'd have to say that that is a breach of fidelity and good faith on the part of the employer. There's obviously no faith in that if you're basically tricked into taking a job that is a nothing job. There have been cases in the past where people are given jobs, probably on good money, in order to take them out of the game, in order to stop them working for somebody else in a way that undermines their career. Well, that's deceptive. It's probably, there's a statutory implication, that's section 31 of the Australian Consumer Law, deceptive and misleading conduct with respect to the way employment is offered or the aspects of it, etc. But even if that statutory provision is not violated, then if a person is not getting what they expect, or not given what they expect, or given what could be held that they could have expected, but in an unreasonable, arbitrary and perhaps unexpected way, that does not breach section 31, then it's still probably a breach of that implied term of fidelity and good faith. Then there's care and skill. Both sides have to exercise care and skill towards the other. It's work health and safety, and adherence to it is implied by law. Care that goes beyond that statutory prescription is part of fidelity and good faith. Entwined very carefully into that, and sometimes overlapping that, are intellectual property rights of the employer, confidential information of the employer, and restraints of trade after employment ends. But those are express provisions. You can't have an implied restraint of trade, and I think that Smile Dental case was where there was no specific restraint of trade. You can have an implied entitlement as an employer that a person will keep confidential information confidential, and that probably is closely related to saying that they will keep faith with you and be honest and exercise integrity with you. So they do overlap. They're not exactly the same, but they're all related, and I think that's why the High Court left it open. This idea of trust and confidence, that is, you have to act in a trustworthy manner towards me, and I have to have confidence in you, is a way of saying you have to act in a common law way towards me with procedural fairness, just as I have to be fair and reasonable with you. Now, that's probably opening the gate to statutory provisions that are very clearly specified for only segments of the workforce into the general workforce. That's probably where the High Court was wary of letting that happen. But fidelity and good faith, you cannot have an employment relationship by any level without trust, in the sense of I am going to serve you faithfully in a way that I contracted to serve you, and I am going to treat you faithfully in a way that I employed you to do, so that the person has that reasonable expectation. There's a case in Australia, Spotless Group Limited versus Blanco Catering, that can be found in 2011 Federal Court of Australia. Now, this was a person who left employment, a senior person. I think we're probably talking about senior persons. A senior person left the employment of Spotless Group Limited and to set up in shop for himself. But what he did was he set up not in shop for himself, he set up shop, and his wife was made the director. And it was found, was implied, was entertained that The reason he didn't just resign and set up shop for himself was that he wanted to get over a trigger date so that he could recover long service leave from Spotless. And so he was found there to have breached his duty of loyalty, fidelity and good faith. This case recognises that the employee is entitled to make preparations to leave, but what this fellow did was he effectively left. He was working against them. He was still taking their money. If you're going to take someone's money, then you have to really do in your bit in exchange for their bit. And their bit is they're paying you, and your duty is to do what they say. I want to steer clear of restraints of trade, but since there's no implied restraint after you leave, the only restraints are a continuation of what you were obliged to do during the employment. So probably in some circumstances I can't think of too many readily, because the only one I can think of is confidential information. That continues on after you leave, but your fidelity and good faith probably exclusively resides in the employment relationship. Now, I have to give an acknowledgement here. Andrew Fraser of the University of Wollongong is a 215 paper, and he does talk about a lot of what I've just said, under the implied duty of fidelity and good faith. Now, where did it come from? And the idea is that the servant must serve the master, and that arises from, well, it's the basic exegesis of British common law employment law. That is, the feudal system evolved with the Industrial Revolution, where persons who had a job for life, that is, an indentured labourer on a manorial estate, left the manorial estates due to the Enclosure Acts of the mid-1770s, were forced into relationships of master and servant from which they could be dispensed at will, but that evolved into the law of master and servant. So the law of baron and serf disappeared because the feudal system disappeared due to the Industrial Revolution, was replaced by the law of employment. That law of employment meant that people were dispensable and people were vassals. Well, entitlements and rights started to evolve, but they started to evolve in one way, because if you were a vassal to one fellow and you could go somewhere else, then you could do what you liked. And so they had to start imposing loyalty. And that first case there is Nicol and Martin from 1799, kid you not. An action, and this is very similar to some of the things we hear now. It's an action against an ex-servant for poaching the former master's customers. Lord Kenyon, presumed deceased, the matter was in 1799, relied on apparently on doctrine that a servant, while engaged in the service of his master, has no right to do any act which may injure his master's trade or undermine his business. But the restraints of trade issue came in. He was free to compete after he left, but he couldn't do it during. So probably the restraint of trade while you are employed is fidelity and good faith. It's probably more an employee duty than an employer duty, but it's one of the manifestations of employee duty is that. The servant's liability to his master lay only on a contractual undertaking for diligence and fidelity. Now what that means is what I was talking about with the builder's labourer. That person has obviously an obligation, but not as onerous as a more senior person, has an obligation to come to work and work. So perhaps the old days in the New South Wales railways, where people would come to work and sleep, or these are practices that don't exist now. If anyone from the railways is watching, I'm sure, and they used to have overtime where people registered for overtime, waited for the administrative office to shut, and then all went home, but still claimed their overtime from 9 o'clock. Apart from obtaining a financial benefit by deception, which was a crime, there was also a breach of fidelity. It means you couldn't be trusted, you were being unfaithful. So a breach of fidelity and good faith. Now the master had a right that evolved very, very early to dismiss summarily for injury to the business. This suggestion that you're discovered now in the 21st century poaching your employers, contractors or employees to go and set up business for yourself somewhere else, that would be a breach of fidelity and subject you to dismissal for misconduct. You could probably go beyond that if the employer could show loss and damage because of your misconduct rather than the remedy for dismissal. The remedy could be more than just terminating your employment. The remedy could be recovering money from you if you expressed that sort of betrayal. Well, that's law now. That was law in 1837 in the matter of Amor versus Ferron. The more senior you became, the more onerous the duty of faithful service. And we have to look also at the corporations law. We're not talking here about statutory obligations, but the statutory obligation under the corporations law of fiduciary accountability and breach of confidence, those also evolved in the 19th century. So we came very, very quickly, probably not, we haven't evolved a great deal. There was one case where a person was found to be engaged in a breach of contract by doing share swaps on the side, which I'll come to. But before we do that, Prince Albert versus Strange, which is an 1849 case, a master printer was restrained from reproducing copies of etchings which he had contracted to print on the basis that such use was a breach and therefore amenable to Chancery's original jurisdiction. By the time of Morrison versus Mowat in 1851, it was accepted that equity would intervene to prevent the misappropriation of a secret by breach of faith or contract. There's circumstances of confidential relationship, such as a partnership. Now, in other words, the equitable evolution and the common law evolution is what we've got to today, which is that you cannot work against the person who is paying you. You have to work for the person who you are contracted to. Now, that case about the person with the share swaps, that was a case from 1886. A confidential clerk from a mercantile firm sought for wrongful dismissal. The employing firm defended the dismissal because what he'd been doing had been heavily speculating in differences or share futures contracts. I had no idea share futures contracts existed in 1886. They did. And he had been speculating in share futures contracts for some time. He'd been doing it with their money, apparently. Now, his argument was that he had not committed serious misconduct in the course of his service or engaged in behaviour resulting in loss. In fact, the speculation had, in all probability, led to a clear profit for the employer. This approach, which was rejected by the Court of Appeal, the Court of Appeal held that the dismissal was justified because he became financially enmeshed in share speculation, while at the same time he was regularly called upon to give investment advice to the firm's partners, and he had placed himself in a position where he could no longer be trusted to perform his duties in a faithful manner. In other words, what master was he serving when advising his employer? Was he saying, this is what you should do that's good for you, or this is what you should do that's good for me? So it's a conflict of interest. Fidelity and good faith is a conflict of interest concept. Lord Esher, E-S-H-E-R, said this: where a person has entered into the position of servant, if he does anything incompatible with the due or faithful discharge of his duty to his master, the latter has a right to dismiss him. The relationship of master and servant implies necessarily that the servant shall be in a position to perform his duty duly and faithfully, and if by his own act he prevents himself from doing so, the master may dismiss him. So if an employee is discovered to be working against the interests of the employer, that can happen. I think probably the other token is that if the employer is found to be acting against the interests, as I've discussed earlier, of the employee, they have the remedy of termination there and then, accepting the repudiation of the contract and suing for the prescribed notice period. I think the employer can go further, and it's unlikely that the employee could, but depending on the circumstances they may. But if the employer can show that the actions of the employee other than exercised in fidelity and good faith, the employer could recover damages from the, by then, former employee. So the remedy can go beyond dismissal. Then there's one case called Boston Deep Sea Fishing and Ice Company versus Ansell, and that's an 1888 case. The defendant was the managing director and therefore owed duties as a director as well, also held to be an agent. He was authorised to act on behalf in commissioning the building of new fishing smacks. What he did was he accepted commissions from the contractors. Now, there was no evidence that I could see here that the outcome of the contract with the contractors would have been different had it not been for the secret commission, but he had acted on his own behalf and not on their behalf. So that person's receipt of commission was in breach of his duty and of confidence owed as an agent, and a position of agency arose from the position of servant, and the court held unequivocally that his act of obtaining a commission was from the shipbuilding company, which I think I just learnt myself there that a smack is a fishing boat, was enough to warrant dismissal. I think they could have gone further. Well, they couldn't, obviously, because they had to build the ships. If they couldn't prove that they were paying more for the fishing boats than otherwise, that they hadn't suffered loss and damage, their remedy was termination. And the judge said there can be no question that an agent, if you're getting a secret commission and you're an employee, you're also an agent at law, employed by a principal or master to do business with another, who unknown to that principal or master takes from that other person a profit arising out of the business which he is employed to transact, is doing a wrongful act inconsistent with his duty towards his master and the continuation of confidence between them. This is where we're getting to now, the case of Boston, where Lindley J said, what right has any agent to use materials obtained by him in the course of his employment for his employer against the interests of that employer? So you're not allowed to work against the interests of the employer. What you're doing when you've entered into an employment contract is each of you are acting in your own interests. One is being paid for their skill, for their position in the profession, for their contacts, for their abilities, and for their know-how, and therefore is not being undermined. And the other is simply a faithful servant, and if not a faithful servant, then can be terminated. The case of Robb versus Green, which was 1895, the basis was that a servant shall honestly and faithfully serve his master. He shall not abuse his confidence in matters of appertaining to his service, and he shall by all reasonable means in his power protect his master's interests in respect of matters confided to him in the course of his service. Well, that is the law then, and it is the law now. But in the 20th century, it moved into repudiation of contract, that you actually, if you're not acting with fidelity and good faith, then you're repudiating the contract. And that is the idea of being sacked for misconduct. That is, you're acting in a way that an employer could not be reasonably held to regard that the contract was still on foot. So the position there is that the contract is you're going to do a good job for the employer, you're not going to merge your interests with the employer's interests, and you're going to be faithful. Now, if you're not, then that's not the contract. You've breached the contract, it's no longer on foot, and it can be terminated without notice. That's a case called Wessex Dairies, where language is now evolved into probably what we talk about, that is conflict of interest and repudiation of contract. In 1946, this was a case of moonlighting, which I talked about earlier, where moonlighting for a competitor of their employer. Now, depending on, I suppose that builder's labourer who's working for Mirvac could go across and work for Lend-Lease moonlighting, so long as he wasn't doing anything that damaged Mirvac other than working somewhere else on his own time. But how could a senior manager, say, work for the nearest competitor at the same time they're working for employer number one? Then we get into Blythe Chemicals versus Bushnell. Now that's a 1933 case, and it's a much referred to case. This is what McTiernan said. Conduct which in respect of important matters is incompatible with the fulfilment of an employee's duty, or involves an opposition or conflict between his interest and his duty to his employer, or impedes the faithful performance of his obligations, or is destructive of the necessary confidence between the employer and employee is a ground of dismissal. I suppose we've got into trust and confidence there a little bit, but it's all these words are probably just merged just a tad. But if you're acting unfaithfully, then you can be terminated. There has to be actual conflict. There had to be an actual conflict between personal interest and duty to justify dismissal. I think in the corporations law it could be something that laid down the possibility of there being a conflict. But if there's no conflict as a matter of employment law, then there's no conflict. And there's not a breach of fidelity and good faith. It's only if you commit the act of lack of faith. So if you're caught using the employer's resources for your own purposes, and there have been dreadful cases where people have been discovered conducting their own businesses on the employer's premises using the employer's equipment, then that is, well, there's other remedies there, but that is also obviously a breach of faith. Stealing is a breach of fidelity, but stealing is remedied in another way. But the High Court precedent of Concut does say that the duty of fidelity imports equitable obligations, or even to assume that an employee's contractual duty is identical to a fiduciary one. The New South Wales Supreme Court, Mainland Holdings versus Sardi, Downer EDI versus Gillies, 2012 New South Wales Court of Appeal, and so on. And Concut is Concut Proprietary Limited versus Worrell. That's a 2000 case. So the contractual duty is a fiduciary one, but I think that the fiduciary goes further if it has the potential to cause a conflict or cause damage. Now, Canada probably confirms what we're saying. There's a case called Canero, the Supreme Court of Canada talked about the fidelity of duty of senior management. They said that the fidelity and good faith concept is a senior management case. That's Canero is a case from 2000, but I don't think the Australian evolution goes quite that narrowly. I believe you'd find that there's a contractual and equitable remedy for fidelity and good faith for everybody. The English case of University of Nottingham versus Fischel, which is from 2000, says the implied duty of fidelity cannot be used to derive the existence of employee fiduciary obligations, as the two are different in nature. Both cases also demonstrate the established position that the freedom of an employee to take preliminary steps in preparing to compete with their employer after the relationship has ended will be strongly upheld as being in the public interest in a free market society. So it's not about going back to the feudal system. It's not about indenturing. It's not about binding. It's not about you have now signed up, you're stuck with me and you can't run away. It's about a mutuality. Not saying trust and confidence. It's a mutuality where you will be faithful. Justice Elias in Fischel said, the essence of the employment relationship is not typically fiduciary at all, although I think that does seem to have been implied. I think there's one can be one. One doesn't exclude the other, but what's not one doesn't necessarily make it the other. The essence of the employment relationship is not typically fiduciary at all. Its purpose is not to place the employee in a position where he is obliged to pursue his employer's interests at the expense of his own. The relationship is a contractual one, and the powers imposed on the employee are conferred by the employer himself. The employee's freedom of action is regulated by the contract. The scope of his powers is determined by the terms, express or implied by the contract, and as a consequence, the employer can exercise considerable control over the employee's decision-making powers. So it is a law of master and servant. You are saying you are going to be engaged in a loyal service with the employer, and they're going to nurture and encourage you and not undermine you. So that's probably a good law, and that's the English one. Item Software versus Fasihi, which is also an English case. The employee in question was a director and they had a fiduciary duty. It's commonplace to observe that not every employee has obligations as a fiduciary to his employee, the builder's labourer, to his employer. An employee has an obligation of loyalty to his employer not necessarily owe that exclusive obligation of loyalty to act is in an employer's interest and not his own, which is the hallmark of any fiduciary duty owed by an employee to his employer. The distinguishing mark of an obligation of a fiduciary in the context of employment is not merely that the employee owes a duty, but of single-minded or exclusive loyalty. Now, you just simply have to do the right thing by an employer, and that's not a fiduciary duty, that's a contractual one. So the employee has that duty. It's a mutual duty of fidelity and good faith. Both sides have it. Both sides can't breach it. It remains the law, and it's very, very significant that in spite of the fact that there's some overlap in some occasions and in some concepts and in some facts with trust and confidence, which is not implied in Australian law anymore, then it still exists. So it's something that is really worth looking at if you've got a common law case against an employee or an employer at time of breach or in time of some sort of dispute, or someone has damaged you. Obviously, the loss and damage aspect of any of these things has to be is overlooked by the authorities because it just discusses the concepts, but the facts of each matter stand on their own. Now, I hope that's been useful, and I hope and I look forward to the High Court doing what it basically implied that it wants practitioners to do, that is, present it with a case to consider the concept of fidelity and good faith in due course. I believe, based on the jurisprudence going right back into the 18th century, the trail would be broken if the concept of fidelity and good faith was abolished as a legal implication in contracts. So thank you very much, and I hope that's done something for you.